The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. 2 cases will be submitted this afternoon. Those cases are Beverly Nance versus the Iowa Department of Revenue. And the second case is In re the Marriage of Jody and Timothy Erpelding. We'll now hear the arguments in Nance. Mr. Stanley.
May it please the court. The document at issue in today's hearing is a transfer on death document instrument, not a transfer on settlement instrument. Because of that, and because the document is valid today, the department is requesting a reversal of the Court of Appeals decision. And in doing so, the court should make at least 2 holdings. First, the court should affirm Wells Estate, Sheely, Bliven, and the district court in this matter, insofar as settlement agreements do not change how property passes from a decedent and are therefore irrelevant. And second, this court should provide guidance by clarifying that when Van Duzer uses the term enforceable right, it does not mean the right to file a lawsuit, as Ms. Gardner has done in this case and claims to be an enforceable right. Rather, enforceable right is a surviving spouse statutory right to take election to take an elective share. The department makes these requests for 3 reasons. First, the beneficiary form at issue in this case, a transfer on death instrument from Edward Jones, is subject to the provisions of Iowa Code Chapter 633D. Based on these provisions, the property subject to this transfer on death instrument passed to Miss Gardner Nance instantaneously on Gardner Sr.'s death. Second, Ms. Gardner Nance's assertion that all settlement agreements be honored for inheritance tax purposes unless there was fraud and if the document was negotiated in good faith is contrary to the statutory law and more than 100 years of the jurisprudence of this court. And third, the Court of Appeals erred in interpreting the relevant statutory and case law concerning this matter.
Counsel, what's our standard of review? The parties had disagreed on that in the briefs.
The standard of review is for errors at law to see if the district court or the Court of Appeals misinterpreted the statutes. There is no dispute as to the facts in this case. A little history probably is instructive. At the beginning of the administrative process, Ms. Gardner Nance was asserting that Gardner Sr. was incompetent when he signed the document that the transfer on death document, that when he left it to his only son, he and his wife left it to his only son and to Miss Gardner Nance, who was the son's wife at the time, if he predeceased her. And that was the argument in the administrative level. And then the argument morphed a little bit and added on that family settlements as a matter of course could alter how the assets from the decedent passed to the eventual beneficiaries. By
Isn't the taxpayer in this case stuck with the legal consequences of the contested case adjudication that rejected her challenge of the transfer on death instrument? And shouldn't that adjudication be binding on the tax consequences?
Yes, that Justice Waterman is one of our arguments of error of the Court of Appeals. The district court found that exact thing, that the agency and the fact finder in the case had made the determination, and there wasn't a substantial evidence challenge to the district court on judicial review. They affirmed the finding based on the director being the designated fact finder, and then it went to the Court of Appeals from this court. That issue wasn't even an issue. It was simply whether family settlements should play in determining inheritance tax. The competency issue wasn't even raised at the appellate level, and so because the transfer on death instrument is still valid today, it wasn't rejected by the probate court. There was a settlement before that. There were 3 bites at the apple at the ALJ, the director, judicial review. All of them affirmed that Ms. Gardner-Nance did not meet her burden of proof to invalidate the document. And so that's why we think this is a pretty straightforward case, that the law says document is a transfer on death document. It hasn't been invalidated, so it controls the outcome of the case.
Let me ask a question. This kind of puzzled me about the way the DOR handled this case. Is it your position that the TOD is valid unless the probate court set it aside, or do you get to go, or because actually the DOR gave these parties a crack at coming into the DOR and proving to the DOR's satisfaction that the TOD was invalid, and that seems to me a little bit unusual. Is that process? Is it your view that process is mandated, or was that just something that DOR was doing voluntarily?
Well, the director chose to, and the ALJ chose to let them present evidence and make that claim in the administrative proceeding. I agree with you, that's very unusual, and the usual course of events is that there's it's either invalid at the probate court decision or it's not invalid ever. This was an unusual case. The district court didn't decide it, had some of the same trouble that you have, Justice Mansfield, with it, but said they were just assuming for purposes of judicial review that was a valid exercise. But I think that's an open question. But you know, we in the Revenue Division, we don't argue against our own director, and so that was her decision, and you know, that was done in this case.
Doesn't that distinguish this case from Van Duzer, in that in Van Duzer there was no adjudication that validated the you know, the will in that case? And
yes, there was no. It is a difference between Van Duzer, but we believe the biggest difference with Van Duzer and the other line of cases that we've cited in the brief is the fact that in Van Duzer, the contestant had a election to have a spousal share, and so it seemed like the benefits of that inter vivos trust was not being included into the estate where the surviving spouse could take a surviving share. And many times in the Van Duzer case, even though it may not be as clear as we want, they talk about the spousal share and the reason it's distinguished from Bliven and Wells and all of that.
I mean, I hate to criticize one of our court's own opinions, but the distinction between that and what was that earlier case seems to me a little bit contrived. I mean,
Living, yeah.
there was, yes, the widow has a right to elect a spousal share, but would not have gotten at those assets otherwise, under the spousal share, but for the family settlement. So that does strike me as perhaps maybe not the strongest distinction, right?
Well, as the court said there, it would have been better had there been 2 checks. It would have been better had that been a cleaner process of doing it, but they didn't want to put formality over getting it right in terms of enlarging the spousal share, which was the ultimate issue. Many of the federal cases that Ms. Gardner-Nance cites also talk about spousal share as opposed to settlement agreement. They're somewhat irrelevant because they're talking about the federal state tax as opposed to the inheritance tax. But the concept of spousal share, which is one of the fundamental concepts of inheritance tax law, is the same. And I think that while the decision, that's why one of the first things I asked for was that this court clarify Van Duzer, and it really comes down to this. There's a difference between an elective share and a contest. And Ms. Gardner-Nance is trying to equate the two by saying if you can contest the will, then you can have a family settlement agreement. But a contest is a very different legal matter than if you just take an enforceable elective share against a will or against a
But counsel, doesn't Van Duzer stand for the proposition that the parties through a post-death family settlement agreement altered the amount of inheritance tax owed?
Yes, under the conditions of a spousal share. That's why they were able to alter that, is because the spouse in Van Duzer had an enforceable right under the law to get a spousal share and to get more of the assets than she was given.
Why does it make a difference whether the family members are challenging in Van Duzer a inter vivos trust versus a will in this case or in Bliven?
Well, it didn't. This is a Edward Jones brokerage account, but it really doesn't matter what the document is or what the avenue is. They were able to challenge because spouses, men and women, are entitled to 1/3 elective share of their spouse's assets, and so that's why that was different.
Our law generally encourages settlements. Why shouldn't we give effect to family settlement agreements? Apparently that's common in the federal system.
Well, we're all for, let me answer in a couple of ways. One, we're all for settlements. It's just that it doesn't change the tax consequences. And, you know, one of the axioms of tax law is you can do whatever you want, but you have to take the tax consequences of what you do. And so anyone can settle. They just need to know that in Iowa law, it's what's taken directly from the decedent that is the taxable event. If it ends up with someone else after it's passed through some things, it didn't pass directly from the decedent, and that's the taxable event. So the fact that it passed through a family settlement, even if it was funneled into the estate, you have to look at how did it get to the estate, and that's something the Court of Appeals got wrong. And so the other thing is on the federal settlements. I know in the reply brief, they said, you know, the feds can do it, you can do it. As we talked about the federal government, it's an estate tax, and I think anyone that was listening at all during the tax reform debate the last few months realizes that the federal estate tax affects very few people. Inheritance tax potentially affects a lot more people in this state, and to require the department to do an analysis to see if there's a good faith settlement agreement or fraud settlement agreement is just unworkable. And not only it's unworkable, it's contrary to Iowa law, because Iowa law doesn't provide for taxation on settlement agreement. It provides for taxation on death, and that's plain in the law. I see I've used my time. Thank you, Chief Justice.
Mr. Stanley, thank you as well. Mr. Repp.
May it please the court. I'm going to start where Mr. Stanley left off, and his primary argument is that the only time a family settlement agreement can apply is when it affects a spousal elective share against an estate. And I don't know why that would be the only time that would apply. That, in my mind, seems very random. You know, there are many causes of action, you know, that can apply to any kind of a transfer document, and that's what we're kind of asking and looking at today. And we're looking at Van Duzer, which actually applied a situation. There was a spousal elective share situation in that particular case, but all that the spousal elective share does is provides the spouse as a beneficiary of that estate. And if you look at the spouse as a beneficiary of an estate, then you can look at the grandchildren, in our case, the Nance case, as a beneficiary of the estate as well too. In the Van Duzer case, the spouse who was a beneficiary of the estate received 1/3 of the estate, which was enlarged by a revocable trust, which the surviving spouse said was an underlying cause of action that she had, you know, to make that trust void ab initio, claiming that it was illusory. That enlarged the estate in Van Duzer. It's exactly what happened in our case as well too. The grandchildren, in our case, claimed that the transfer on death designation was void because of incompetency, another state law cause of action. And then because of that, it enlarged the estate, and the grandchildren were beneficiaries of that estate. Really,
But one difference, though, and perhaps a fatal one to your position, is that here we have the contested case adjudication of the competency issue, which your side lost. How do you get around that?
well, when you say the adjudication at the
Well,
administrative level?
At the agency level, affirmed by the director and never set aside in district court, that, I mean, you had made a run at proving incompetency of this Mr. Gardner Sr., and the adjudication was that a failure of proof on that issue. So why doesn't that establish as a matter of law for our tax purposes today that the inheritance tax was owed on the full amount of the transfer upon the death under that TOD instrument?
When we made the decision to make the appeal to the Department of Revenue and Finance and we presented our evidence, we decided to go down two separate roads, two separate causes of action, two separate arguments that we could make that we thought we could win on. Two of them. One is that we could claim that Lester Gardner Sr., the deceased taxpayer, and the deceased person in that case, was just incompetent. So that involves a lot of providing a lot of evidence, substantive evidence to prove that he was incompetent, bringing the doctor's testimony in, and almost a full-blown litigation again. That was one path that we decided to go down. The other path we decided to go down too, parallel to that, is that we have the Van Duzer case, which says that we can use the family settlement agreement that we had before, and as long as it has a valid underlying state law cause of action. I wrote 4 elements that I thought were necessary in order to justify that settlement agreement, and then that would give credence to the
Can we ignore path 1 and that outcome now?
Yes, we can. Yes, we can. Yes, we can. Because we're going to solely look at the family settlement agreement and whether or not that was valid. whether or not they actually had a fighting argument underlying that family settlement agreement. And that will distinguish, the sham type of transactions, which is the department is most concerned about. And I'm concerned about that as well, too. We don't want to support any kind of sham tax transactions here. You have to have good faith, as the Court of Appeals said, and no intent to avoid taxes. So you put those two together,
But my issue with that line of argument is that all family members on both sides of that settlement are gonna benefit from reducing the tax liability. Every dollar that's avoided in inheritance tax is a dollar they can divide amongst themselves. So in that sense, is it truly an arm's length negotiation without the Department of Revenue at the table?
Well, certainly it is. So in our particular case, we had adverse parties. Our client, Beverly Gardner Nance, clearly wanted that transfer on death benefit.
But don't they have common interest in avoiding inheritance tax?
Well, that was all in the settlement agreement as well, too. So Beverly Gardner paid all the inheritance tax as if she had inherited it all and paid all that. And now she's asking for a refund of the part that she agreed to give to the grandchildren as a part of the family
And I mean,
settlement
you
agreement.
have this sort of strange situation where she was going into the DOR saying, well, actually, my father-in-law didn't know what he was doing when he gave me the money, right? I mean, that's kind of weird.
Well, in that case,
You would acknowledge, right?
Yeah, she didn't even know that the father-in-law had even done that. That came as a surprise to her. She didn't know that until after her father-in-law had died.
I mean, here's the thing. I kind of agree with your reading of Van Duzer that it's a case where the documents said one thing, there was a challenge to the documents, there was a settlement, and the settlement was followed. But then we have that other case, Bliven, where the documents said one thing, there was a challenge, there was a settlement, and the settlement was not honored. And so, maybe we have to pick and choose between these two approaches in our law.
I don't think
We can't
so.
reconcile the cases, right?
Yeah, so here's how I reconcile the cases. Here's how I think the cases should be reconciled. In Bliven, we had a situation where Amy Bliven, the decedent in that case, was deemed to be mentally incompetent. She had a guardian and she had a conservator. That person walked in on Amy Bliven at some point after the conservatorship had been established, and she tore up her own will. Now, the cause of action in that particular case was that, well, she was incompetent to tear up that will. There are some charities that were beneficiaries of that will, and they're the ones that made the claim saying, hey, that will was not voided, it was not torn up. We should be able to probate that will. Now, here's what happened in Bliven, and it's absolutely clear in the Bliven case, is that the parties in their settlement agreement stipulated to the fact, both the charities and the family beneficiaries, that the will had been torn up and voided by Amy Bliven. They agreed to that. That's the equivalent of a litigation foot fault, if you will. But that's absolutely clear. And the court had a very easy time with that because in all situations they said that, that the will was valid and the charities really was not valid, and the charities didn't have any kind of a right under intestacy to those assets. That's how we distinguish Bliven. Also, the Wells case, in a 1909 case, that same situation occurred there too. Okay? So really there are two ways that you need to think about here with regard to settling this case. Number one is it the substantive law? And does our case follow the Van Duzer? Are we similar to the Van Duzer case? Therefore, Beverly Gardner, then the family settlement agreement would be given credence with respect to the tax laws here. Other ways are policy issues as well, too. And policy issues are very important in the state of Iowa, because clearly we don't want to have a situation where we're going to have taxpayers who are just going to be doing these fake family settlement agreements just in order to avoid tax. That's wrong. We can't do that either as well. So how do we do that? Well, the Court of Appeals used the good faith argument, and they said that there should be no intent to avoid tax. I suggested, good faith is kind of a vague and ambiguous term, and I thought that we should maybe add some more elements to that, maybe some objective factors. Maybe an objective factor could be, you have to show that there is an enforceable legal right as a part of the good faith. Another one could be that you have to be adverse parties. The department has claimed also, too, that, well, that's just going to cause all sorts of problems with enforcement because we have to prove somehow that there was some sort of underlying cause of action and the strength of that. And I'm saying, no, you wouldn't have to do that, and you could say no as well, too. the department can put the burden on the taxpayer to show good faith. And this happens very frequently in other parts of the tax code, so it wouldn't be very unusual as well at all. If we follow the rule that the Department of Revenue and Finance, that we have to have a full determination on the judicial settlement of this matter, going to trial, having a legal settlement, court judicial settlement, determination on the merits, that would have caused us to have to go to court and have a full determination, put on evidence, waste the court's time, even though we knew that we were probably going to lose. And the grandchildren probably would have won everything. Had that have happened, there would be zero inheritance tax that had been due. Instead, we settled, and we took half, the grandchildren took half. We are willing to pay our inheritance tax on the half that we got. So you could say that the department is a beneficiary of our family settlement agreement as well, too. So I feel pretty confident that we would have lost that case had we gone to trial. We were fortunate to get what we got. These types of things where you have a strict, hard, fast rule, where no family settlement agreements apply at all, can be costly to taxpayers because we have to go to court, have to hire lawyers, have to take all of our time to do that. It can be unfair to the taxpayer because we're having to pay
You kind
tax.
of did this anyway with your Path 1. I mean, you had live testimony from your medical expert on the incompetency issue.
Yeah, that's exactly right. So good point. So if we have a family settlement agreement, in order for that to be given credibility for tax purposes, we almost have to relitigate this entire issue again, and we shouldn't have to do that. Taxpayers shouldn't have to do that. I don't think the department would want to have to do that. They have to sit through that and listen to that as well, too, make their own determinations. So this actually, if we have a Van Duzer type of an outcome, could actually benefit the Department of Revenue and Finance by lowering their administrative costs on this. Okay? There could be some very absurd results from this as well, too. So in our case, our underlying state law cause of action was incompetency of Lester Gardner Sr. All right. You know, what if there was something that said that Lester Gardner Jr., that's the son who, you know, what if he had taken his dad down and forged his name and given that forged name to Edward G. Jones? And the Department of Revenue and Finance would say that, well, okay, it's a forgery, so be it. That's his name right there. We're going to follow that transfer on death beneficiary designation, even though it wasn't actually Lester Gardner Sr.'s signature. And it could get even worse than that, too. You could get into coercion, fraud, duress, any of those situations. There's no exclusions.
But in this case, the grandchildren were claiming undue influence of somebody's incompetence, so it's basically they're arguing Beverly, was a beneficiary of that. I mean, aren't we all better off with an adjudication of the challenge to the instrument that controls the taxation?
Yeah, well, I think that'd be fine, and I would be okay with that. If you wanted to tell us that we have to go to court and get a full determination on the merits, rather than enter into a family settlement agreement, it's going to be very costly to litigants. It's going to be a waste of judicial resources because we know that we're going to lose, but we're going to have to go to court in order to get the tax benefits from it. I don't think that makes any sense. That's not the policy that I would want the state of Iowa to adopt.
It shouldn't. Go ahead.
What about this, the regulation? I recognize it doesn't strictly talk about TOD, but the one that says beneficiaries of an estate may contract to divide property in a manner contrary to the will, but the department is not a party to the contract, is not bound to compute the shares of the estate. Department must compute the shares based upon the will unless a court of competent jurisdiction determines the will should be set aside. Now, when I took tax in law school, it's been a long time, but my understanding was generally tax regulations really have something like the force of law because of the importance of predictability in this area. I mean, doesn't that put you on notice that DOR is not going to honor family settlement agreements?
Two responses to that. Number one is that does not apply to us as a transfer on death. It only applies to wills. Number two, I think that particular rule that was adopted by the Department of Revenue and Finance just flies in the face completely of the Van Duzer case, which clearly upheld a family settlement agreement to void a trust which enlarged the estate, which gave the benefits to the surviving spouse. I don't know how you can have a different opinion on that. Unless you have any more questions for me, I've said all that I think that I've needed to say. Thank you.
Mr. Repp, thank you. Rebuttal, Mr. Stanley?
Just want to cover a few of the points that Mr. Repp talked about. One is that they made the settlement agreement, they said throughout this, because they knew they would lose in the probate court if they went going forward. I think it was just a lack of confidence, because in the administrative process, they took the side they thought they would lose to, and at 3 levels, they lost on that side. So that it wouldn't have been a futile effort. And then to the stipulation, they said as part of the Bliven case, there was a stipulation that the rule was, that the will was revoked. But look at the irony to this case. I think Ms. Gardner-Nance went well past a stipulation, because she actually went from defending the document in the probate court to saying the document was invalid 3 times in the administrative and judicial review process. So in terms of abandoning a position, I think she went well beyond what the charities did in the Bliven case. I think, as Mr. Repp says, he thinks it's unfair the way we have it now. The remedy is really for that to go to the legislature and try and get these transfer on death documents changed to some other form, because aside from a constitutional issue, the courts really don't get to rewrite laws because they think they would be more fair. We happen to disagree. We think the bright line test is important. Last time I was here in September arguing the Alcorn and Tyler case, we talked about the bright line test there. For the state to have to carry out a very extensive law on the inheritance tax, the bright line test is good. And it doesn't stop any kind of settlement. It just means that when you settle a case, you have to take into account the inheritance tax that's due. So here there was inheritance tax of somewhat under $20,000, a benefit of a couple $100,000, and so you have to realize that you take that. As part of the settlement agreement, it says, and this gets back to one of the earlier questions, it says that the parties are going to split any refund that they get back. So the fact that people are getting some benefit from getting out of the tax is important.
I mean, you say we should go to the, these folks should go to the legislature. And I mean, the statute says the entire amount of property, interest and property income passing to the lineal descendants, basically, which is, what was the result of, is exempt from tax. I mean, passing to is not the paradigm of clear, precise drafting. And if we ask what the legislature intended, isn't there a fair argument that the legislature would have intended a good faith family settlement agreement to be honored?
No, Your Honor. Passing means passing from the decedent to any of these people. Through a family settlement, you're inheriting not from the decedent, you're inheriting from the settlement agreement, and that is not taxable at all. The inheritance tax only applies to what is passed from the decedent. That's all inheritance tax is. So if you have it go through a different level, it's only that first level that gets taxed, decedent to whoever gets it from the decedent. After that, it's not inheritance tax anymore. It's not a taxable event. And so,
I mean, passing indirectly? I mean, what's... That's a possible reading.
No, I don't think it is, under the jurisprudence of this case. In Seeley, which we have in the brief, it says the probate court shapes the administration so as to carry out the contract, but no theory or fiction of the law does the title bypass the heirs or beneficiaries and pass direct from the decedent to those designated by the contract. It is instead accurate to say the probate court implements the contract instead of such implementing being done by formal conveyance. And so really by Iowa law, and these cases are all in our brief, let me just say one thing about the Van Duzer, and if you can have these kind of settlements. There's a case cited in Van Duzer in Sayers Estate that says, again, we stress the fact there is no evidence of an intent to evade the tax in the instant case, but that fact is immaterial. It is a tax case, and all tax decisions have an effect on subsequent decisions beyond the limited area of the specific issues. Were we to sanction transfer where no tax evasion was intended, we would be providing a loophole when tax avoidance could be secured and the transfer tax defeated. And so it really, over 100 years of jurisprudence says it's taxed directly from the decedent to the beneficiary. And in this case, that's what was taxed by the department. Thank you.
Mr. Stanley, thank you as well. Mr. Repp, thank you. The case of Nance versus Iowa Department of Revenue is now then submitted, and we'll next hear the arguments in the Erpelding marriage.